without some specific authority allowing them to do that, I do not believe that they can argue it in such a way that it elicits sympathy. Basically, you can feel sorry for the defendant. Since they're specifically instructed that they can't. So I think there are ways that they can argue the concept without the court giving it the weight of an instruction that's not approved by the Florida Supreme Court.
Okay. Mr. Lahr?
Yeah, both of the cases cited by Ms. Drain's verdict preceded the standard jury instruction in 2009. What they had back then basically was you consider anything in a person's character, which is basically what the mitigation is. However, the Supreme Court, I guess, during their deliberations realized that we needed something more. It says that you cannot, you're not required to impose a death penalty. And so that's why I pointed the court out to page 415. They talk about the fact this is their mercy instruction. But again, as I stated from the outset, if it's not there, then they may not realize they can actually utilize mercy. I would also point out that when I was referring to the argument,
Well, Mr. Lahr, let me stop you there, because Ms. Burdick's response to the last part of my question was, unless there's authority that would allow you to argue mercy, what authority are you relying on that allows the argument of mercy? And if it did allow it, what were the instructions to the jury in that case? Did it have the word mercy, or was the word mercy absent, but nevertheless the argument was permitted based on an instruction similar to what the Florida Supreme Court has put in 7.11?
well, I would say the case law that she provided did not have anything that was elicited in the standard instructions that were passed in 2009. That's when they switched over to say, in any event, not required. And what I would point out is when we talk about the difference between the federal and state system, which is state reference, if the jury comes back and says life is the sentence we impose, it has to be imposed by the court. There is no way around that. You cannot override a life recommendation. And so it does have the same weight, and that they should have before them all the things they consider. They can consider the aggravator, they can consider mitigating, but they can also consider mercy, which again, this, what we're requesting, kind of highlights what they're allowed to do. And as I was starting to say, this case, which was in the Ninth Circuit last year, tried by Judge Kemp, albeit with policy from Ms. Ayala, forcing it to go to another jurisdiction. The problem when there's this thought that if it's not in the instructions and you constantly say you must follow the law as laid out in these instructions, that if it's not there, they're going to say we cannot consider mercy. And we believe that this may be an oversight because maybe it was something that wasn't considered by the court at this point. And as you stated at the beginning of this process, that there's no presumption that these are correct. You know, so we think this is an addition that is required and necessary, and does not, and if it's left out, does not fully inform the jury of what they can and cannot do.
Your Honor, I'm sorry to interrupt before I was getting ready to speak.
Yeah, I was going to ask Mr. Lahr, what's the case that you're relying on that involves the use of the term mercy in closing argument? Or a jury instruction?
Is you can use it when you see Perry versus State talks about final jury recommendations, as sometimes they're referred to as a mercy instruction. And it's with Perry versus State at 210 Southern 3rd 630, and that's at page 24. They talk about the way it's currently written, where it says, regardless of your findings However, you're neither compelled nor required to recommend a sentence of death. That is one case, Gregg versus Georgia.
I'm sorry, do you have a copy of that?
Yes,
That I can,
I provided you to the court last week.
I'm sorry, let me,
So,
I have that stack, but I don't know if that's the same.
and actually, there's another case, I can provide all of these to the court, Harvey versus State, which is 946 Southern 2nd, 937. They're talking about an attorney who was being held ineffective because he was attempting to distance himself from an argument by the jury. But what they said was that the trial court reviewed the statement and found that counsel's final argument was a well-organized plea for mercy, and it's supported by the record. And in that regard, they found that it was not ineffective, which means that the mercy instruction would be something that would be permissible. I'll give the court all of these cases again.
Thank you.
Thought I might be referring to.
Does the state have these cases?
I provided them last week at the same time I provided to the court.
All right, I've reviewed the case law provided by the defense. I'm sorry, Ms. Berg, is there some cases you were relying upon?
The only case other than what I've already talked about would be this Gonzalez case, which is at 136 Southern 3rd, 1125. Give a copy to the defense, specifically the ideas discussed starting at, referenced in head note 51, but starting at the printed page 32 of the opinion. The issue there is a little different because in that instance, the defendant on appeal was trying to claim fundamental error in the courts giving the instruction that your verdict cannot be based on feelings of prejudice, bias, or sympathy, that somehow precluded him from, or excluded mercy, the concept of mercy, from the jury's consideration.
And I'm sorry, Ms. Berg, where is this in the opinion?
The printed page 32,
32.
and it's head note 51, which is...
Got it? Okay.
In that, it's a little different than what we're discussing here, because the defendant in that case did not object to trial, so they were considering whether or not it was fundamental error to have instructed the jury that they could not be influenced by feelings of prejudice, bias, or sympathy, and that instruction excluded mercy from the jury's consideration. The court rejected that argument and then couched it in terms of similar claims regarding jury instructions on the role of sympathy. And that's at the end of that paragraph, starting with head note 51.
Ms. Berg, I'm sorry, Ms. Berg, on the defense proposed instruction, I'm looking at, it's got several sentences, but looking at the first two proposed sentences, you're never required to impose a death sentence. You have complete control and discretion to determine whether or not the circumstances of this case justify a sentence of death. So those two sentences, okay, they don't contain the term mercy. What would the state's objection to those two sentences being given?
Well, first of all, the first sentence is already stated in almost those exact terms above. The law neither compels nor requires you to determine that the defendant should be sentenced to death. That's that same concept.
Mm-hmm.
Secondly, the sentence that talks about you have complete control and discretion in determining whether or not the circumstances of this case justify a sentence of death, that's not true in Florida. Because even if they come back with a verdict of death, the court can override that. That does not appear to be the case in the federal system. So I believe that to be an incorrect statement of the law. And the rest of that, except for the last sentence, is just a reiteration of what has already been explained above regarding the weighing process. And then it's the state's position that the last sentence is contradictory to the instruction that says you cannot consider sympathy.
Mr. Lahr, what's your response to the state's argument that it would be improper to instruct this jury on mercy if mercy is synonymous with sympathy?
One, I think that is incorrect connection. And I looked at the case that she provided, and of course, it doesn't really talk about the fact of sympathy. However, if you look at the Perry case, one of the cases I gave you, it recognized the fact that mercy is something that is permissible. And the problem is that we don't believe it articulates it sufficiently enough for the jury to be able to understand that it is something they can give. So we're not equating mercy with sympathy. That is not what this is. It's basically saying mercy, that you can extend something you can bestow upon somebody. Just by nature of the fact that you feel that's the right thing to do. It's not going towards sympathy in any event.
And Ms. Burrick, looking at, it is the Perry case under Headnote 12. It refers to language that's very similar to the language in the current instruction, and regardless of your findings in this respect, however, you are neither compelled nor required to recommend a sentence of death. And then goes on to say that this final jury recommendation, apart from the findings, that sufficient aggravating factors exist and that the aggravating factors outweigh the mitigating circumstances, has sometimes been referred to as the, quote, mercy, close quote, recommendation.
Right. That doesn't, I think it's dicta, number one. Number two, it's not a specific authorization to instruct the jury. It seems like a colloquial term that is describing the specific instruction that's already given, which is you're not compelled or required to, in this situation it was recommendation for the death penalty. But I do not believe this stands for the proposition that the court can instruct the jury that they may consider mercy. And one of my concerns is this is an undefined term. Who gets to define it? Defense counsel in their closing statement? I mean, if you look up the term mercy, it means many things. Let's see. Compassion, forgiveness, lenience. I used the word grace before. Pity, sympathy, tolerance, beneficence. Mercy in and of itself also has a religious connotation associated with it, which would be inappropriate in this context. they can argue that what this instruction means is that you can extend leniency to the defendant. There's nothing that's going to preclude them from making that sort of argument, that that's what that instruction means.
I don't know necessarily that that has religious connotations. I mean, if you look at least one definition of mercy, which seems to make a lot of sense, is compassion or forgiveness shown towards someone whom it is within one's power to punish or harm. So, that is a definition, but again, I don't see any religious connotation to that. But it does allow for one to bestow that on. And again, it seems a little counterintuitive if the courts recognize mercy as an option that the jury can do. Why would you not tell them that they can do it in very explicit, precise terms and not have them guess at it?
Well, we could ask the Florida Supreme Court why they didn't include that then in the instructions that they approved a little over a year ago.
Where's the reference to sympathy in the standard instruction?
Number 3, your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone.
So the word sympathy is not used in this 7.11 as it is in the others?
Looks like they separate out in number 6, that your decision should not be influenced by feelings of prejudice or racial or ethnic bias. They separate out the concepts of bias and prejudice from feeling sorry for anyone or being angry at anyone.
Right, so they don't use the term sympathy, it appears, in 7.11.
I don't see it.
All right, based on what's been presented, the court's granting defense request in part, denying it in part with modifications. With respect to the blue highlighted underlined language that I have before me, the first sentence, you're never required to impose a death sentence, will be given, but it will start with the phrase, but again, comma, you are never required to impose a death sentence. The reason the court's doing that stylistically is because the instructions proceed until, as was mentioned already, the existing instruction, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Then it goes into another paragraph that gives further instructions, and then it says to repeat what I have said, and then repeats essentially what is, in a very summary way, what is recited before. So stylistically, it makes sense to the court that we would then say, but again, you are never required to impose a death sentence, because that is a repeat but summarized of the language at the end of the paragraph that precedes the paragraph that starts, once each juror has weighed the proven factors. And then the last sentence, you may always consider mercy in making this determination, will be given based on my review of the case law, specifically this Perry v. State case, where the Supreme Court itself used this term of mercy recommendation to apply to similar language. The other sentences will not be given because I do believe they are unnecessarily duplicative and repetitive.
Judge, just so I'm clear, since I'm editing here,
Sure.
it's the first sentence, although I've added the "but again," and the last sentence.
Correct.
Okay, thank you.
The state objects to the court giving a non-standard instruction in that fashion
All right.
regarding mercy.
Does the state have any proposed language in view of the court's ruling? Any additional language on this issue? Since I've granted it in part, if there's additional language the state wants to propose, I would consider it.
No, I believe that the entire instruction is unnecessary and not a correct statement.
Okay. All right, going on to the next issue. Ms. Moore, is this going back to you?
Yes, Judge.
Actually, let's take a brief recess and then we'll come back. Thank you. All right, so the defense is requesting which ones of the 6 through 10 be given?
8 and 9, Judge, I believe are appropriate. I believe we impeached at least once Dr. Pritchard. I believe the state tried and may have with Dr. McLean. And then I believe since Mr. Nelson testified, number 9 is appropriate.
All right, so the defense does not believe currently numbered 6, 7, 10, that they're not applicable.
We believe they are not applicable, correct?
The state disagree as far as 6, 7, and 10 as currently numbered being removed?
Agreed.
Okay. All right, so 6, 7, 10 is currently numbered be removed, and the state agrees that currently numbered 8 and 9 should be given?
Yes.
So 8 will be renumbered as 6, 9 will be renumbered as 7. Okay?
Judge, then the next highlighted paragraph is the defendant became a witness in the case. We believe that should be given. It's appropriate. And alternatively, the next paragraph about him not being a witness should not be given.
State agrees with that? Okay. All right, so the first highlighted portion with the defendant in this case become a witness, that paragraph will be given, and then 1, 2, 3 paragraphs down referring to the defendant exercising fundamental right, that paragraph will be removed. Okay?
Next is in the rules of deliberation. The state has number 5 highlighted. And to be candid, I can't remember if there were any questions during the penalty phase. I don't think there were. So I don't think it needs to be given.
I don't recall a question during the penalty phase.
There were no factual questions, but I left that in there in the event the court felt that these notes where the forewoman is communicating was somehow covered by this. I know before we even started, they sent a note out saying, we want a projector, we want
Correct.
number of pages. That wasn't really addressed with them.
Okay.
Either way.
I guess, is there any objection to including it, just in case in the mind of some juror, they think a question was asked and this would instruct them how to deal with it?
No.
All right. So we'll leave that in there, just in case there's something, some of the things that we've been mentioning, I do recall that may be viewed as a question. There may be something that no one's recalling that happened that would be covered by that. Okay.
The final thing that needs to be addressed is the exhibits and how the court wants to instruct the jury as to that. I believe all the exhibits and the penalty phase are all things that can go back. They're photographs and documents. I don't think anything can't go back. But I don't know how that relates to the evidence from the guilt phase and how the court wants to handle that. I think it would be probably easiest if we just used the same language from the previous instruction, though I don't have that in front of me.
Yeah, I don't have that in front of me, but the language we used before should be adequate.
Judge, I kind of took the initiative to cut and paste the same exact instruction that we used in the guilt phase to put into here. I can read it out loud if you want me to, but I just cut and paste from the guilt phase jury instruction.
As long as it's the same from the guilt phase, that seems to make
Yeah.
most sense to me.
And if I recall correctly, we didn't refer to specific exhibit numbers, we referred to a category like weapons,
Correct.
biohazard.
What it says is during trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of the exhibits will be sent into the jury room with you when you begin to deliberate. However, exhibits that contain biohazardous materials or weapons cannot be sent into the jury room. If you wish to see any exhibits that are not sent into the jury room, please request that in writing.
Judge, that's fine.
All right. And so, as we did before, council will just have to make sure, I don't know how they've been maintained, if they've been maintained separately, as we had already sort of segregated them, and now we have the defense exhibits. I don't recall, I believe everything the defense admitted evidence was innocuous. No weapons, no biohazard.
They're pictures and documents only.
Okay. All right.
Judge, as to the instructions, the only other thing is to go back to the ones the court hadn't made rulings on. I'm not sure if the court's ready to do that, or if you want to move on to the verdict form.
No, we can go back. That way, Ms. Hicks or whoever's doing the changes to the jury instructions can do that while we move on to the verdict form.
If I'm
Alright.
correct, I think the first one is as to aggravator number 2, and specific, the state had agreed that some instruction, additional instruction would be appropriate, but we weren't agreeing on the language.
Did state and defense prepare differing versions, or?
The state provided us with a different version. I don't think still are on agreement, so I think we need the court to make a determination as to that.
Okay. Does the defense disagree with everything the state's proposed, or,
No.
and wants to stick with what it proposed, or is there a partial agreement?
I don't remember exactly the wording of the state's suggestion, but our main issue with their suggestion is that it doesn't include the language about it being a life-threatening crime, which we believe is taken directly from the case law and is appropriate.
All right. Do you have, Ms. Hicks, do you have the language?
I can read it to you, Your Honor.
Okay.
So the language that we proposed is, in order to prove this aggravator, the state must prove beyond a reasonable doubt that the facts and circumstances of the bank robbery with a dangerous weapon involved the use or threatened use of violence against a human victim. So the sort of the main difference between ours and theirs is that they want to call it a life-threatening crime, and of course we don't. That gives a connotation that, and we believe the defense wants to be able to argue that nobody was actually, it wasn't a life-threatening crime because it was a taser and he was arguably nice to everybody and didn't physically threaten anybody and used a fake bomb. Therefore, it's not their lives were never actually threatened, but that's not what the law requires. The law simply says that it either has to be the use of violence or the threat of violence. And obviously what the witnesses testified to was that he threatened them with the bomb. The fact that the bomb ultimately was fake is not relevant.
So Judge, our position is that the life-threatening crime language comes directly, is quoted directly in the law and quoted directly in the Mann case, and the Mann case is quoting directly a Lewis case that comes before it. So it is an accurate statement of the law, and so it's our position that the life-threatening crime portion should be included. I believe that essentially their instruction and ours is the same in the beginning, up until my instruction says that the facts and circumstances, and then I say of the prior case, I believe they say of the bank robbery with a deadly weapon. I have no objection to changing it to that specific, the bank robbery with a deadly weapon. And then I believe it should say was a life-threatening crime. And then I can't remember the end of the states, but I don't think I had an objection to it.
And the life-threatening aspect, you're relying on the Mann case?
Mann case, which is also citing Lewis, and that is a direct quote from that case.
Okay. And the state's relying on what for
The standard.
omitting the use of life-threatening?
The,
To be clear, Judge, when it's starting with life-threatening crime in which the perpetrator comes in direct contact with human life is all the quote from Mann. It's directly quoted from that.
You know, I mean, Judge, if you look at the standard jury instructions, what the law requires is that the defendant has to have been previously convicted of a felony involving the use or threat of violence against another person. That's the standard jury instruction that's comes to us from the statute that we're obviously talking about. And so, again, using the term life-threatening suggests that it has to have been, and the defense has even basically sort of suggested this in their argument. They've talked about how it was a fake bomb and how it was a fake taser and nobody was actually.
Ms. Higgs, I'm sorry to interrupt, but Ms. Moore, yeah, I'm looking at my notes. What I thought the parties were going to meet and convert, because I rejected the defense argument regarding the Mann case, because it was distinguishable. Isn't that the one where the person was the getaway driver?
Yes, Judge. I believe that the court had, right, as to my argument with sufficiency, then we had moved on to the language. And so if the court is rejecting that, I understand. But
What I'd ask Ms. Moore, what I'd ask the defense, do you have a case that says the language use or threat of violence to another person has to be life-threatening, other than the Mann case?
Not, that Mann is citing to Lewis, which is another case that uses that exact language. It's not citing, it's
Lewis?
quoting Lewis, which I don't have it in front of me, but it's literally quoting it. Yes, Judge, in the Mann case, which is 714 Southern 2nd, 391, it says, as we stated in Lewis versus State, which is 398 Southern 2nd, 432, Florida, 1981, the finding of a prior violent felony conviction aggravator only attaches to life-threatening crimes in which a perpetrator comes in direct contact with a human victim. And it's quoting Lewis starting at two life-threatening crimes. So that's directly from Lewis, which then Mann is quoting Lewis.
In your hand, is that Mann or is that Lewis?
Yes, this is Mann, which is quoting Lewis.
So you don't have Lewis?
I don't have Lewis with me, no, Judge.
Okay, well, while you have Mann, since I looked at that before lunch, let me see it again. Thank you.
Somebody.
Right.
Judge, I can provide the court with Lewis. In that case, it's a case involving a shooting where the defendant was the shooter. But one of the prior convictions in those cases that they were relying on was breaking and entering with the intent to commit a felony, escape, grand larceny, possession of a firearm by a convicted felon. And the court found that none of those crimes spell into the meaning of the aggravating circumstance, because the subsection refers to life-threatening crimes in which the perpetrator comes into direct contact with a human victim. So in that Lewis case, that's the holding is that you have to find that language. And I can print that case for Your Honor, so that's what the language is being quoted by Mann comes from.
All right, Ms. Higgs, could you write out your, I need to see your instruction, your proposed instruction.
Handwritten the state's proposal.
Oh, thank you.
And Judge, if I can approach with a copy, or made, or printed a copy of Lewis, did you get both copies? That's all the time.
Thank you. All right, Ms. Hicks, with respect to the state's proposed instruction, says, in order to prove this aggravator, the state must prove beyond a reasonable doubt that the facts and circumstances of the, then it lists the charge, bank robbery with a dangerous weapon. Does the state have any objection to the word prior going before the word bank?
No.
And what would be the state's objection, if any, to, and then continuing on, bank robbery with a dangerous weapon involved the use or threatened use of, and you have violence against a human victim. That's what's proposed. What would be the state's argument that the adjective life-threatening should not precede the word violence?
I don't believe it's illegally, I understand the case law they're citing, but I don't believe that, again, it suggests a connotation, and what I believe the defense intends to argue, which would be objectionable, is that the actual crime had to be life-threatening. Like I'll give you an example. I believe that what they would want to be able to argue, imagine the prior.
Well, let me stop you about what is proper argument, because right now we're just talking about what's the correct statement of the law. So why would it be a statement of